sections in question are Ahmedabad St. Xavier's. 41 subsection 4, which was eventually struck down by majority of 7:2, read as follows. The relations of the constituent colleges and constituent recognized or approved institutions within the university area shall be governed by the statutes to be made in that behalf, and such statutes shall provide in particular for the exercise by the university of the following powers in respect to the constituent degree colleges and constituent recognized institutions. 1. To lay down minimum educational qualifications for the different classes of teachers and tutorial staff employed by such colleges and institutions and the conditions of their service. Now, because this clause came into question, the conclusion, which if you'll just note down that page number, it's not there in my note, it's at page 319 of volume 1. The order of the court. And there is a more recent judgment of Justice Narimans, which also looks at it as a 7:2 ratio. I think last time, Justice Datta, we were discussing whether it was 8:1 or 7:2. There is a recent judgment also, but even from this, if you see the sections which are struck down by each of the judges, you'll find that it does come to a 7:2 ratio. 319 bottom, last paragraph. Order of the court. Ahmedabad.
You're referring to sections 41?
Yes, 41. So by order of the court, they've said so-and-so as amended do not apply to institutions established and administered by linguistic and religious minorities. All parties will pay and bear their own costs. Now, in KMA Pi, they sustain the fact that the minorities under the constitution are both linguistic and religious. Now, being both linguistic and religious, while today many of these are Jesuit institutions from Tamil Nadu, etc., which are taking this, it would equally be a Gujarati institution or school in Delhi or in Bombay or in Bangalore, etc. So, both linguistic and religious minorities are not required to have such minimum criteria imposed on them by the state. This is where I feel there is a consistency between both Ahmedabad St. Xavier's and Pi. Pi's clarity is provided in this phrase. So really what would be tested with reference to any particular institution or group of minority institutions would be that the procedure for both the recruitment and for disciplinary action would be a rational one. And that I believe is available for testing. If any issue is taken up by the government or anybody else saying that the procedure by this institution is not a rational one,
You said it's section 41, subsection
4 small Roman letter. Which page? It's page 232, madam.
Good.
Page 232.
Yes. It says to lay down minimum educational qualifications.
Yes, for the different classes of teachers and tutorial staff employed. We've given you a list of 6 or 7 of the more important judgments which have followed this rationale of Pi, which include both the Islamic and Inamdar, which are the Pi follow-ups in 5 and 7 judges respectively. I don't want to hear it. 2020. Well, just if your lordship want to note, 2020, volume 13 SCC, page 411, at para 23, which is Chandana Das. At para 23, Justice Nariman's bench says, the 9-judge bench in St. Xavier's by a majority of 7:2 held so-and-so. So it appears, at least from our reading, that the ones who held differently were Justice Beg and Justice Javedi. Now, Millards, I'm coming to Roman 3 at page 2. I don't think we have taken your lordships through Society for Unaided, Millards. And if your lordship will have with me volume 3. Yeah. I'll just start, Millards, with page. I want to start with 50%. Page 101 of volume 3. RTE Act first came under challenge in this matter, the large number of challenges were really to the 25% being imposed. I mean, as an aside, I can just tell you, Lordships, yesterday I noticed that in Justice Narasimha's bench, Mr. Senthil Jagdishan has been appointed as an amicus to assist the court on these EWS admissions. Because what is happening in, while 25% there on paper, it's actually not taking place. There's a lot of interference by the private schools by not allowing those 25% in. So to ensure there's a transparent system and a quick online system, etc., that court is considering it from all states and central governments. Now, the reason why I'm starting with page 101 is para 1 of the majority. There's a 2:1 case. So the dissent is by Justice Radhakrishnan, who starts at page 101. It's a part dissent. And the majority para 1 starts by referring to this dissent and saying that they find themselves unable to agree on a few points. So the entire issues are fully set out by Justice Radhakrishnan. So if I can take you to where his judgment starts, it refers to Article 21A and the RTE. Now, from para 61, if I can take your Lordship's 67, if I can take you to para 69, the petitioners in all these cases, it may be mentioned, have wholeheartedly welcomed the introduction of Article 21A in the Constitution and acknowledged it as a revolutionary step providing universal elementary education for all the children. Controversy in all these cases not with regard to the validity of Article 21A, but mainly centers around its interpretation of the validity of sections 3, 12(1)B and 12(1)C and some other related provisions. The reason I'm showing you this is that it was not just section 12 which was under challenge, but several other related provisions, which includes 23. So it was a comprehensive look that the court took at the RTE when they dealt with this case. If I can take you now to the if I can take you to page 149. From para 269 onwards. 269. From para 269. Fourth line of para 269. I'm sorry, my Lord Justice Hasan. It's page 149. 140. Yes. Para 269. The private unaided institutions, apart from challenging 12(1)C, have also raised various objections with regard to other provisions of the Act. Therefore, they deal with 3, 6, 7, 8, 9, and 10. And then para 270, they deal with 13, 271 with 16, section 16. Section 17 is in para 272. At 274, they deal with, in the fourth line of para 274, they deal with 23. With regard to section 23 of the Act, the Council submitted some of the unaided private education institutions employ the teacher from outside the country as it encourages cross-fertilization of ideas and education systems and practices, and the qualifications provided by the institutions may not be as prescribed under 23 of the Act, and the qualifications provided therein may not be sufficient for appointment as teachers in the schools affiliated to the IB system. The Learned Council appearing for the unaided private education institutions also referred to rules 9, 11, 15 and 23 and explained how it affects their autonomy and status of their institutions. These are the arguments. And then there are several paragraphs dealing with sections 14, 15, etc. And then the finding on 23 is at para 284. Section 23, in my view, would not take away the freedom of aided minority educational institutions for the reasons already stated by us. Please mark aided, because that's what this judgment says. No infirmity is also found with regard to sections 24 to 28 of the Act, since the object and purpose of those provisions are to provide education of satisfactory quality, so that the ultimate object of the Act would be achieved. At page 157 are the final conclusions after this. At para 311. Just see conclusion 2, para 311 at 157 bottom. Para 311, para 2, sub-para 2 there. Rights of children to free and compulsory education guaranteed under 21A and the RTE Act can be enforced against the schools defined under 2N of the Act, except unaided minority and non-minority schools not receiving any kind of grants to meet their expenses from the appropriate governments or local authorities. Just pause for a minute. So the exception here is therefore to unaided institutions. So aided minority institutions come within the capture of this. Now, if I can take you. No, that's it. Yeah. Yeah, and one last thing at para page 158, absolute end, small para 13. Madrasas, Vedic Patshalas, etc., which predominantly provide religious instructions and do not provide for secular education, stand outside the purview of the Act. The reason I'm showing you this is because the amendment to the RTE Act, which comes in section 1, is in view of these findings. There's a partial dissent. So this is actually the majority agrees with a couple of these conclusions. Now, if I can take you to the majority mark, which starts at page 82.
Aided minority
Is what this judgment says. It's overruled in Pramati. So page 84 is where the majority starts.
overruled in Pramati. Was there a question?
Yes.
Framed
Yes.
in that? Yeah.
They specifically say so. They say to this extent society is overruled. So page 84, we have to give you a clear picture of how things evolve. Page
Majority conclusion started 100.
Yes. 100, no?
100.
Yes, just above Justice Radhakrishnan.
Right.
Yes.
So we have no problem with one.
Yes.
Says to an aided school, including aided minority school,
Yes.
receiving aid or grants
Yes.
to meet whole or part.
Correct. So para 61 to 63, if you just see.
62 last line.
Yes. 62 makes that.
Last line.
Yes. Last line of say para 62. Thus, the 2009 Act, including 12(1)(c), violates the right conferred on such unaided minority schools under 31. However, when we come to aided minority schools, we have to keep in mind 29(2). As stated, 31 is subject to 29(2). The said article confers right on admission upon every citizen into a state-aided education institution. Article 29(2) refers to an individual right. It is not a class right. It applies when an individual is denied admission into an educational institution maintained or aided by the state. The 2009 Act is enacted to remove barriers such as financial barriers which restrict his or her access to education. Enacted pursuant to 21A. Applying the above tests, we hold that the 2009 Act is constitutionally valid qua aided minorities. And para 65, they bring in Chamar Bagwala, the severability test, to therefore read this down as far as aided institutions are concerned. Para 65. However, the said 2009 Act, and in particular 12(1)(c) and 18(3), infringes fundamental right granted to unaided minority schools under 31, and consequently applying RMDC, principle of severability, the said 2009 Act shall not apply to such schools. Right?
Only the unaided have been kept outside the aided.
Correct, by society. But
Aided is covered.
aided is refuge. That's by this judgment. Now, this judgment does two things. One, comprehensively goes through all the sections. Justice Kapadia doesn't reproduce it. Chief Justice Kapadia doesn't reproduce it because he says in para 1 that Justice Radhakrishnan in his judgment has dealt with all the provisions. That's why I took you through the dissent to that extent. But all three agree on this conclusion. That's why I showed you both conclusions. Now, this is what the position was.
So as far as aided, as far as the Aided minority institutions are concerned, they have to follow the TET requirement.
If society was the governing law today. If society.
Correct.
That's it.
Now in your
Pramati, Pramati, yes. So, if I can just show you, Lordship, if you come to the RT Act for a minute, page 13 of volume 3, same volume, page 13, 1-3.
Volume
3, same volume, page 13, 1-3.
1-3.
This is volume 3.
Yes. They come forward. Yes.
Because if your Lordship sees section 1 at page 13, the Act is on page 13. Section 1, just see the subclause 4. Clause 4. Subject to the provisions of Articles 29 and 30 of the Constitution, the provisions of this Act shall apply to conferment of rights on children to free and compulsory education. So it's subject to that. This is an insertion,
2012.
in 2012. 1st August 2012.
Before Pramati.
After Pramati.
Before.
Well, sorry, after society. After society, before Pramati. And the other one, that's why I showed you the last conclusion 13 of Justice Radhakrishnan's husband. Nothing contained in this Act shall apply to madrasas, Vedic pathshalas, and education institutes, primary imparting religious instruction. Both of these were inserted in 2012.
But in Pramati, we didn't find any discussion about the Act as such.
Very limited. Very limited. So there in passing, not with the X. In all of it,
Mainly confined to 16(5).
yes,
CW. But you cannot.
because the exhaustive discussion.
Ask a question. What is volume 1?
Volume